A very good afternoon. Study circle meeting for the financial year 26-27. We are glad that Chief Guest Karare sir and the guest of honors, all the respected MSTP members and the members of the newly formed GSTPAM present here. So I request everyone with a loud round of applause. I request President sir, escort Karare sir, and I request Vice President Jatin Bhai, escort sir to the. So before we begin, it is customary we start any event. Sure. Before that, I request son of Scott Speaker Siri sir. So now, as it is customary, begin any event. I request members on the dais as well as on the dais to please secretaries to please escort stop on. Before we begin, we request the President of GSTPAM, Shri Mazgaon, to say a few words.
For this first state circle meeting for the time of 26, 27, respected past president, respected chief guest, GSTAT members, the past president present, office bearers, my dear friends. It is indeed a privilege for all of us today that we have with us Honorable President of the Maharashtra Cell Tax Tribunal, Sri P.S. Tarare sir, as the chief guest for the first study circle meeting for the term 26-27. Sir, we sincerely thanks you for accepting our invitation and gracing this occasion. This is our tradition that we need the Honorable President and the chief guest and the members of Maharashtra Tribunal as a member for inaugurating the study circle meeting. For the first time, we have also invited registered members as for this our inaugural study circle meeting. I sincerely thanks on behalf of the GSTPAM member and all the dignitaries for accepting our invitation and blessing this August gathering. So today's topic is GSTAT appeals on the Delhi combination for the planning for hearing and merits. We are fortunate enough to have with us the learned speaker and our past president, Advocate C.B. Thakar, sir, who will enlighten us on this important subject. We thank him for accepting our invitation. I extend to welcome again to all the degree here in the physical also as well as on hybrid mode. Meetings, workshops, seminar, refresher course, organizing guidance cell meeting, conducting coaching classes and orientation courses, making representation to the authorities in the interest of trade and industry, publishing a monthly news bulletin with important updates and decision, and providing access to our website containing the acts, rules, and notification important judgment. I sincerely thanks our Law and Represent Committee Chairman, C. Pranav Kapadia, Convener C. Umang Talati, Ashish Ruparila, Dipali Mehta, and Monag Bhatt for their dedicated efforts in organizing an inaugural study circle meetings. Friends, study circle meetings are the backbone of our association. They help us learn, update ourselves, and grow professionally. I am also confident that today's session will be interesting and beneficial for all of us. Today, we have Dharinder Rana sir from GSTAT Mumbai. He is a judicial member and inviting him as a chief guest. I really sincerely thanks for accepting our invitation and given a time for us. Thank you. Us. Let's proceed further. Umang.
Thank you, President, sir. Now I would request the chairman of the Law and Representation Committee, CA Pranav Kapadia, to say a few words.
Good afternoon, everybody. respected chief guest, Honorable Shri P.S. Tarare sir, respected guest of honor from GSTED, Shri Dharendra Rana ji, our president Vinod Maske ji, the speaker for today's study circle meeting, our own and our past president Shri C.B. Thakar ji, the office bearers on the dais, the honorable tribunal members who have come here to grace the occasion from Maharashtra Sales Tax Tribunal as well as the GSTED Tribunal, past presidents of our association, our committee members, uh, and other dignitaries from the department who are now into the GST profession as a professionals. I welcome them also, Akhade sir and our Morales sir, Morales sir, and all the members present online also. A very warm welcome to all of you. Well, yes, the winds of GST are blowing fast, and yeah, although this lamp because of the winds can get blown away, but I think the light of learning, the knowledge which needs to be shared is a continuous process, and which we at GSTPM have been continuously doing it year on year, every year, and through various knowledge based activities of our association we have been carrying it out through. And as a tradition, whenever the new committee comes in every year, the first inaugural study circle meeting, we have the honorable tribunal members with us, and the uh, president of the Maharashtra Sales Tax Tribunal is the chief guest, and that tradition continues. I'm very much thankful to Sri Tarare sir and all the members for coming here and gracing this occasion. And as far as the topic for today's study circle is concerned, well, the tribunals have started functioning. Uh, Most of the matters, I think, as of now, are at admission level, and condonation of delay is one of the most crucial matter for all the taxpayers, as well as a bone of contention between the taxpayers and the department that whether the appeals can be admitted or not. There have been a few judgments or the beginning of a few judgments which have come, and we really need to understand the impact of them, and I'm sure the tribunal members are also here. Maybe they will also be able to guide us on the way forward of how justice will be given to the taxpayers who have missed the bus in the initial stages, although a lot of time was earlier given to file the appeals before the tribunal. But yeah, I think that still possibly needs a finality and a justice to the taxpayers, and I'm sure the August gathering over here will guide us on how to proceed on these matters. With this, I once again welcome all the dignitaries on the dais and off the dais, and wish you all a happy learning for this entire year. Thank you very much.
Thank you, Chairman, sir. Now, I would request the President to please come forward. We would like to honor each and every tribunal member here. So, as a gesture of our appreciation, so first, I would request the President to honor our MSTT President Tharare sir. Uh, Now, I would request the President sir to honor Dharendra Rana sir. He is the GSTAT judicial member at Mumbai bench. Now I would request President to honor Dr. Alvarez sir. He is the technical member at the GSTAT Mumbai bench. Now I would request President sir to honor MS Pathan sir. He is our very own tribunal member at the Maharashtra State Tribunal. Now I would request President sir to honor Joshi sir. President, please, I request to you to honor Jayant Patil, sir. I request President, sir, to honor Dani, sir. And last but not the least, Sir Dumre, sir. Now I would like joint secretary, she is Sunil Joshi, to take over and introduce both our guest of honor and the president, the chief guest.
Good afternoon. Honorable Shri President MSTTC Tarare sir, Honorable Shri Dharendra Rana sir, member GSTPAM Mumbai, all the members present from the MSTT Mumbai, I welcome you all. It is my proud privilege to introduce Shri Dharendra Rana sir, honorary guest of honor. Shri Dharendra Kumar Rana. Sir is a judicial member posted in Mumbai bench of GST Appellate Tribunal. Prior to his appointment as a judicial member in GSTAT, he was a practicing advocate in indirect tax liminary, representing clients in litigation matters and providing advisory services for over 30 years. He was known for delivering high quality services with full dedication and integrity. As an advocate, he regularly appeared before various tribunals and most of the high courts across India, including before Supreme Court in indirect tax matter, GST, customs, foreign trade policy, central excise, service tax, and VAT. He has also supported clients during the investigation before DRI, DGGI, and provided tax and regulatory advocacy services. He argued some landmark cases, including the famous Malabar Paratha case before the Kerala High Court, SK sheet metal case before the Delhi High Court, Avenue supermarket case before the Bombay High Court, Stern India case before the Karnataka High Court, Grazino transmission case before the Gujarat High Court, and many other cases. He was regular speaker in the seminars and webinars organized by the Trade and Industry Association and penned numerous articles on the issues having wide ramification. He was awarded accolades and was recognized by prestigious organizations like Forbes India, Top 100 Individual Lawyers, BW Legal Word, Tax Lawyer of the Year, Legal 500 Recommended Lawyer, and Acromit Point Leading Tax Litigator. With this brief introduction, I present before you our guest of honor, Honorable Shri Rana sir. I request Rana sir to say a few words to the gathering.
Very good afternoon. Honorable Shri Tarare Sahab, Honorable President, Maharashtra Sales Tax Tribunal, the technical members of Maharashtra Sales Tribunal, my brother Shri David Alvarez, before GST Appellate Tribunal, all the president and office bearers of GST Practitioners Association of Maharashtra. Thank you for organizing this, and honorable all the esteemed guests and fraternity, lawyers and consultants, CAs from the bar, from the other fraternities who are practicing in the field of indirect taxes. So thank you for organizing this study circle meeting and this seminar. And the topic that I saw the invite and the topic that is there for today, these are very interesting topics because a lot of litigation is floating around these topics. So when I was going through it, I saw that, first topic is relating to limitation. And as Mr. Kapadia just now mentioned, there are some case laws, some jurisprudence that is evolving. Probably the learned speaker and who will present today's, who will take this study session forward, will discuss all those cases, including the Punjab, Haryana High Court and Kerala High Court and many other high courts. And this issue is also, I would just tell you that, is pending before the principal bench of the GST Appellate Tribunal. They have also consolidated all the cases from various benches, and they have already concluded the hearing in Delhi, and we don't know when the outcome will come, the judgment will come, but yes, they are seized with the matter. They are also considering this aspect because it impacts quite a lot of people, and interplay of various sections. But I can tell you one thing, because as Mr. Kapadia was saying, the members are here. GSTAT is also like sales tax tribunal. We are also creatures of the statute, GST law. We have our limitations in certain form and sense. We are not a High Court or the Supreme Court. We do not have jurisdiction like 226 or 227 or Article 32 for that matter. So the limitation is that within the framework, what can be done, definitely tribunal will do. But we cannot pass orders like, in writ petitions, High Court or Supreme Court can do. Okay. Second topic that I was seeing that was relating to pre-deposit of penalty. Again, there are judgments because this provision itself came late, sometime in 2025 or 24, late 24 or early 25, sometime around that. So there are judgments which say that it may not be applicable to penalties that have been imposed prior to that date. And so again, that is a matter of consideration. One of the GST appellate tribunal, I think Hyderabad bench, has also, they've also ruled in favor that yes, it is not pre-deposit is not required if the order pertains only to imposition of penalty. So that matter. And now coming to the last, which is probably hearing on merits. Obviously, tribunal is the last fact-finding authority, and every litigant has high hopes that at least they'll be able to get justice from tribunal, because that first stage where somebody feels that they are being heard in open, they are being heard, and all their legal aspects, factual aspects will be considered. So that's the expectation, and a very legitimate expectation for any litigant. So tribunals will be there, hearing on merits will happen, definitely. The only difference is, unlike erstwhile tribunals and erstwhile courts, which we have seen in our lives, which are, all paper driven, we are completely e-court, e-tribunal. There is no physical filing. There is no physical, submission of any document, whether it is compilation of case laws or any synopsis or anything that you wish to submit. Everything has to be online. And the good part is that you need not be physically present in the tribunal to argue a matter. Virtual hearing is by default provided, and anybody who finds it difficult can argue virtually. It adds to the advantage because geographies and all these limitations are taken care of. You can be anywhere in the country. You can argue your matter on merits and expect justice to be done. So I think these are the three topics. I thought I'll convey my thanks to the organizing committee, where they've selected these topics for today's discussion. And I also wish to take this opportunity to thank the organizing committee to invite members from the GSTAT and having us over here. Thank you so much.
Thank you, Honorable Shri Dhanendra Rana, sir, for your enlightening words regarding the GSTAT working and the future. Yes. Sir, yeah. I request just before
I request honorable member, just that Sri Dr. Alvarez, please say few words on this occasion of inaugural of Study Limited. Thank you, sir.
Yes, honorable members on the dais and off the dais throughout Maharashtra, those who are watching. Good afternoon, everybody. Yes, Honorable Rana sir actually put up many aspects which we were seeing here and which are different at the GST Appellate Tribunal. Here is I can speak because I have worked here also and I have got an opportunity to work there. It was all paperful office here. All submissions were on paper, but there we see a digital office has come. Every aspect from e-filing of the cases to further procedural aspects on the dais are without paper. And we are not accepting any kind of paperwork. And whenever you have opportunity, everything has to be on the e-filing only. The thing is, when we were working here, there were so many aspects which were being added every time, and probably it was physical arguments and oral submissions which had some weight. There it is a hybrid mode, means no doubt you can argue the things orally also, you can put online also. But the thing is, for every aspect, you have to submit the documents online. First, we thought it is very difficult because we have got, means our office, if you have an opportunity to visit, you can come there. We have got the touch screens before us, touch screens, no, not touch screens, but the monitor before the arguing means arguing pleaders also, before the appellant, before the respondent. So that kind of thing is there. And whatever you want to argue, those papers will be visible for everybody. And in the open court, we have got big screens also. And what is going on there, that can be seen on WebEx, and you can keep the track of things. We have got a small room for advocates because at present ours is a temporary place there, and we have made some space. From there also, sitting there, they can just see what case is going on, what is going on in the inside the court. So these kind of things are there. Definitely, I was opportune here to have the fathers pleading before me, and there we have got the next generation which is pleading before your next generation. So, and they are well versed with all these digital aspects. So we will have, at present, we have started only admission stage. And in that, here I said ki it was just oral argument which was going on, but there you had to give your written submission. We are giving 30 days for filing your written submission. And after that, the further procedure will start. So 30 days for written submission. If there is any cross objection, then 45 days will be given. There are appeals from the department, there are appeals from the taxpayers. And as Rana sir said, definitely we are there to give things on merit. We have got highly qualified judicial members. As such, Rana sir's information about him was put up before him. Another judicial member, Atul Korekar sir, he was Secretary General of Supreme Court of India. So that only suffices about him. Then Kennedy sir, he is Technical Member Center. He was CBIC board member, Miss IRS 1993 batch. Then he was CBIC board member. He has worked in North Block for 8-9 years. So that, and he has studied GST of 20 countries. He was deputed for that purpose. So we have got a cream, and definitely we are eager to decide the things on merit, for which you will not have any difficulties or you will not have any objections as such. So we will try to give and decide the things on merit. So definitely I'll be happy if you people also come there. Second generation, yes, we are interacting with them, but if you come, I welcome all of you. Just I think C.V. Thakar sir was once there and I invited him. So I invite all of you to be there, and we will have nice time, and it will be just intellectual arguments at the higher forum. And your facts will be decided there. So wherever submitting, you see that facts are clearly put up before us. So nothing remains, because once we decide the facts, even High Court and Supreme Court will not take up the issue as far as facts of the matters is concerned. It is only for question of law. It will go to the High Court and Supreme Court. So we'll have nice time. We have started from our temporary premises. I said within 3-4 months, we'll be shifting to permanent premises, and the gestation period of admitting appeals, it was 30 days. From September onwards, we'll be hearing the appeals on merit, and we'll start deciding. Our flow of orders will follow. Thank you so much.
Thank you, sir, for your words of wisdom and getting the procedure of the GSTAT familiar to us. Thank you.
Thank you, President. Now it's my proud privilege to introduce today's chief guest, Honorable Shri P.S. Tarare. Shri Honorable Pramod Tarare, sir. Sir, by qualification, BCom LLB. Sir was practicing in a district and session court, Gadchiroli, Chandrapur, in civil criminal court and revenue court. He has been selected as district and additional session judge in the year 2008. Sir has a wide experience from May 2008. He was a district and additional session judge in Jalna, Yavatmal, Aurangabad, Vaijapur, and Nagpur. He worked as an additional principal judge in Bombay City Civil and Session Court, special judge in CBI Court, Mumbai. He worked as a principal district session judge, Nandurbar, from the year 2018 to 2021. From the year 2021 to 2022, he worked as a charity commissioner of Maharashtra State, Mumbai. After his retirement, he He has joined as a member of Maharashtra Sales Tax Tribunal in the year 2022, and he has been presiding as a president of Maharashtra Sales Tax Tribunal from the year 2023. With this brief introduction, I present before you today's chief guest, Honorable Shri Pramod Tarre.
Dignitaries present on the dais, and my friends, I am truly honored and delighted to extend my heartfelt appreciation to the Goods and Service Tax Practitioner Association of Maharashtra for organizing this study circle meeting. This study circle meeting aims at having in-depth study and discussion on the subject GSTAT, condonation of delay in filing first appeals, in filing second appeals, pre-deposits for penalty appeals, and course of hearing on merits. This study circle meeting will cover business intricacies as well as application of recent changes arising from judicial precedents and amendments. The association has selected the proper person as speaker. The speaker is Mr. C.B. Thakar, who is the Mahaguru in this subject. That is delay, condonation of delay. I am confident that this endeavor will sow the seeds for a brighter, more dynamic future in the realm of tax laws. I wholeheartedly support your efforts. Once again, I express my deepest gratitude and admiration for your commitment to excellence in the legal field. With these few words, I stop here. Thank you.
Thank you, sir, for your kind words of wisdom. Thank you.
Thank you, sir. Now, with this, before we begin the technical session, I would like the Joint Secretary, Shri Ajay Talreja, to give a vote of thanks for this session.
Good afternoon, everyone. Honorable guests, members of the tribunal, members of the GST Act. We are indeed fortunate to have you here today. It has been our long-standing wish to interact with the department and understand about the intricacies, for which we also have our learned speaker who shall guide us through the study circle. I thank you all for your valuable presence here, physically as well as online. With this, I have been basically stressing a lot on having a physical session in the library. There were days when we were here, there was waiting outside the door for people to come in. We want those days to be coming back here now. Fortunately, we have started this year. We had a very successful validity session on 3rd of August, and now we are having substantial people over here. I mean, members over here. Thank you so much for being here and encouraging us in this presence, in this push towards the physical presence instead of being online. Being present physically has its own advantages. Like I already said, even before Google and ChatGPT came, we had our seniors whom we could go to and talk to, and they would give us solutions instantly. That is a best option for juniors like us. We have learned, and I'm sure others will also learn the same thing. Thank you so much. I thank once again all the dignitaries on the dais. Thank you so much.
We would especially like to thank all the guest of honors and the chief guest for gracing the occasion today. So thank you. So we'll just have a quick changeover. I request, if time permits, I would request all the members if they would like to attend the technical session. It would be our pleasure if you would.
Good afternoon, everyone. So now we are beginning with a technical session. And once again, I welcome you all in the physical presence and also the members' presence in online mode. So before that, first we are inaugurating our first study circle meeting. So I request our president to have a few words on the first study circle meeting. President Sir Vinod Bhai Maske.
Thank you, Mona. Yes. Once again, I welcome you for our first study circle meeting. Today's speaker is CB Thakar sir. I welcome him. Respected all past president, senior in professions, my dear friends. Today's subject is GST appeal, delay condonation, pre-deposit for penalty orders, hearing on merit. This is a very important and practical topic for all the professional who is practicing mainly in department appeal as well as in tribunal. Understanding the nuisance of delay condonation, proper word is key, and the requirement of pre-deposits in penalty matters. First time in appeal also we have to pay first appeal 10%, again 10%, 20%. GSTAT will become malamal. And the approach of the tribunal while hearing the appeals on the merit is essential for effective presentation. This subject directly impact on our day-to-day practice, and therefore the today's session holds a great significance for all of us. Friends, under section 107(1) and 112(a), the GST Acts provide the timeline. And that is very crucial for us. थोडंसं मराठीतून बोलतो कारण बरेच जण आउट स्टेशनचे आहेत ऑनलाईनवर. जो कलम 107 आणि 112 जो आहे याच्या अंतर्गत विलंब माफीचा जो मुद्दा येतो तो केवळ तांत्रिक बाब नसून न्याय मिळवण्याच्या दृष्टिकोनातून अत्यंत महत्वाचा आहे. अपील वेळेत दाखल होण्यामागे जर खरे वाजवी व समर्थनीय कारण असेल तर करदात्याला आपली बाजू मांडण्याची संधी मिळाली पाहिजे. प्रकृती त्रुटीमुळे न्याय नाकारला जाऊ नये आणि शक्य असेल तिथे प्रकरणाचा निर्णय गुणदोषावर व्हावा हीच न्यायव्यवस्थेची खरी भावना आहे असं मला वाटतं आणि ती पाळली जाईल अशी मी अपेक्षा करतो. अँड वी ट्रुली फॉर्च्युनेट इनफ टू हॅव म्हणजे मला खरोखर आनंद आहे की CB ठाकर इथे आहेत. इज हायली रिस्पेक्टेड सिनियर प्रोफेशन अँड वन ऑफ द मोस्ट एक्सपिरियन्स authorities I can say. Sir has always guided the profession with exceptional clarity, deep understanding of the law and practical insight drawn from the decades of the experience. त्यांच्याकडे त्यांचा सेन्स ऑफ ह्युमर पण चांगला आहे तर आज पण आपल्याला दिसेल त्याच्याबद्दल काही शंका नाही. His interpretation and explanation have consistently helped practitioner understand the complex issue in a simple and structured manner. Sir, we sincerely thank you for accepting our invitation and for being with us today. Your presence itself is a matter of pride for our association. We are grateful that you have taken time out of your busy schedule to share your valuable knowledge and experience. Thank you. Jai Hind, Jai Maharashtra and Jai GSTPAM. Janak bhai aaye ki nahi? Yes.
Thank you, Vinod Bhai, for your opening remarks over the study circle meeting. Now I request our President Vinod Bhai to offer a memento to our today's speaker, CB Thakar sir. Now I request our convener Ashish Bhai to introduce today's speaker, CB Thakar sir.
Hello, a warm good afternoon to all. I'll formally introduce Advocate CB Thakar, sir. Chandrakant Bhai Shankar Thakar. He is passed CA in 1982 and passed LLB in 1983. He was practicing as a chartered accountant from 1983 to 2004, and he now practices as an advocate. He has submitted and delivered lectures on sales tax in various seminars, conferences, and tax practitioners to students, beginners in practice conducted by the ICAI, the STPAM, there is our association, various regional practitioners associations, and other social organizations like Lions Club, Rotary Club, and etc. He was past president of the GSTPAM for the year 1995-96. He has been past president of the Sales Tax Tribunal Bar Associations for the year 2006 to 2008. He is regularly contributing in articles relating to VAT and indirect taxes in Bombay Chartered Accountants Society, the AIFTP Journal, newsletter published by WARC, the Sales Tax Review, which is monthly published by our association. He has been the chief editor of Sales Tax Review for the years 96-97 and 97-98. He has authored study material for beginners in sales tax laws in Maharashtra for the Western India Regional Council of the ICAI. He has been members of the publishing committee of guide book on VAT audit on the Maharashtra Value Added Tax Act and issues on VAT audit published by the WRC of ICAI. He has co-authored study material on Central Sales Tax Act for the ICAI Delhi. He is also a co-opted member of the research committee of the Central Council of the ICAI for the year 2002-2003.
He's also a co-opted member for the Research Publication Committee of WRC for the year 2009-2010. Something which is not in his CA is he is a Mahaguru, as said by P.S. Tarare sir, and he is an apt person to speak on this topic what we have in hand today. So with this, I'll ask CB sir to take over the session, please.
ठीक है ना थोड़ा करेंगे जाऊँ ना ऐसे क्या करेंगे President of our association, office bearers, all my friends before me. This is the first inaugural section, and those, of course, our Talreja ji already said that previously this used to be a very huge crowd here, but now because of invent of the technology, people are getting information even without attendance, and of course, online is also one of the way to attend. एक बार ऐसा हुआ था पटकर जी एक स्पीकर बोलता था धीरे धीरे सब लोग चले गए वो बोरिंग हो गए क्या हो गया मालूम नहीं सब लोग गए एक ही आदमी बैठा रहा तो उसने पूछा कि भाई यार सब लोग गए अभी तुम क्यों बैठे तो बोले तुम्हारे पास मेरा स्पीकर है तो ऐसा कुछ न हो सो काइंडली रिपीट में ना हियर सो नहीं ये अरे सारो जने he should remain so everybody will remain I think नहीं not in this is overall महागुरु अगर कुछ ऐसा हो तो भी वांदा नहीं है okay friends now we'll go to our topic my first topic is about condonation of delay in filing first appeals in filing second appeals now as we are aware I am given time up to 4 o'clock so I will try to cover before that only. There are first appeals as we have under VAT and there are also second appeals before GSTAT. Now first appeals are before the department authorities like Joint Commissioner, Deputy Commissioner, etc. And second appeals we are filing before the GSTAT. These are normal course of action. Now there may be appeals also out of review order, etc. That is a different thing, but that is what there are two types of appeals. Now limitation. Limitation is provided for the first appeal in section 1071, 3 months from the communication of the order. So this is what the primary time is given. Second appeal they have given under section 112(1), that is 3 months from communication of the order. They are using the words communication of the order, and then in the section 116 etc. it is using service of the order. So anyhow, there is some difference in between these two languages. We don't know why, but it may be useful to us. Then comes, if you are missing the 3 months time, then the issue starts. Now they have said that in the first appeal, the first appellate authority can condone the delay up to 30 days. That is 1 month under section 1074. If there is delay in second appeal, the time limit for condonation is 3 months under section 112(6). now issue arises. Within 30 days also there are issues. There are judgments I have seen where even within 30 days also they have not condoned the delay, subject to their observations and then whatever further happens. But beyond 30 days is going to be a very difficult task. And that is how I think number of persons got caught into this net initially. Nowadays we are becoming more informative and alert. But there was a time when we used to miss it for months and years. In between they gave in 23, they gave one chance to get it updated by paying some cash deposit, 2.5%, etc. And that people have taken benefit, but still the delay is going to happen somewhere and somewhere. So it has to be taken care. I think our professionals' responsibility has increased so far as we as a professional, because the dealer will always rely upon you. Even if he has not conveyed order to you, still he will say, Baba, you are handling my matter. You should have seen that. Why you are expecting me to do everything? So this is how you are on both the nets. We believe that it is their duty. They should check the portal and then come back to us. But still they will blame you. And basically, if you are putting your mobile number or something for this OTP, etc., you should be more careful, because then the communication will be to you. If you are giving your email also, that is going to be difficulty, because it is supposed to be known by you. So now, at least in henceforth, whether you want to take that responsibility or not, be careful, because there may be huge demands and you are not knowing of the order and delay may take place. So this is how some precautions required from our side. The issue arises if the delay is after 30 days or 3 months. Nowadays under VAT we are aware that as per section 81, we can get our delay condoned as per Limitation Act, section 5. And we can apply even if there is years of delay. Still we can go to the tribunal or first level authority and say that this is the reason by which I could not file in time. And they have power to condone, subject to satisfactory reasons. But here the issue has arisen before state authorities whether they can condone beyond 30 days for any reason. It may be medical reason, it may be death in the family, or whatever extreme we can think of. Whether they can still have power to condone or not, that was the issue. And most of the authorities said we have no power. Now, if section 5 applies, they get power. If don't apply, then they will not get power. Now, this is the debatable issue, whether section 5 can apply to GST provisions or not. Now, there are two contradictory judgments. One is of Calcutta High Court in case of S.K. Chakrabarty and Sons versus Union of India. And in that, the Honorable Court has held that since there is no exclusion, specific exclusion that Limitation Act will not apply, or section 5 of the Limitation Act will not apply, the court said that Limitation Act can apply. But still it is not settled, because that matter is taken to Supreme Court by the department, and even the operation of the order is also stayed. So applicability of this issue is still debatable, Calcutta High Court judgment. Now latest we have got a judgment from Uttarakhand High Court. They have given a big judgment referring to a number of cases, and ultimately they have come to conclusion that since there is a specific provision in the GST Act itself, there is no specific exclusion agreed. But the law itself has said you can condone delay up to 30 days. So they say that by inference, indirectly, they have taken out the application of section 5 or Limitation Act. And that is how the present situation is, that Limitation Act will not apply to GST Act unless any liberal judgment come. Now before us also there were judgments under VAT Act. For example, appeals. We have 60 days time. Thakar is also aware about that judgment. And of course, he has also taken one judgment in Supreme Court. And the time limit is where there is no, they compared that for appeals under section 26, etc., they have given application of section 5 specifically. But for filing appeals or under BST Act reference, no such application was made, because that section 5 was made applicable to your appeals filed under section 26. So taking cognizance of that, they say that it means that for filing appeals section 77 before High Court, this Limitation Act will not apply. So they have got this interpretation based on the language of the Act. Here also the same principle apply. When the law itself says that you can condone up to 30 days, automatically it means that they have excluded the application of Limitation Act, Section 5. So friends, having this situation, now what should be our thinking on that? That also I have come down. Now, according to majority opinion, even my personal opinion is also that because of this restricted limitation period, there will not be application of Section 5. That is what I also feel. Of course, everybody can have different opinion for that. But from the language of this provision, it automatically feels that there cannot be further extension after 30 days. But then, friends, High Court has got all the powers, even if there is a delay. But if they are convinced, now Madras High Court is very liberal in that manner. When you go with a plea that we did not come to know, there was only accountant who was looking after and he missed to see this, that. They have taken control of that and remanded the matter back, subject to some pre-depose, etc. So that is possible by the High Court. But so far as appeals are concerned, according to me, either first appeal or second appeal, after given period of 30 days or 90 days, 3 months, they will not be able to condone delay. Now, under such circumstances, suppose you have missed the bus and you apply for condonation, first, according to me, you should follow the legal procedure. Even if you are delayed, file the first appeal. Let them reject, file second appeal before tribunal, GSTAT. And once the GSTAT dismisses it, then you can go to High Court also by way of writ petition that these are the circumstances but not appreciated. And probably you can get the benefit there. Unless you have got a very strong case on writ petition at the very beginning only. So friends, there are other provisions in the Limitation Act. This is the only one regarding delay condonation, which is very, of course, very important and very important for us, everybody. But instead, the other provisions are also there in Limitation Act, like Section 4 of the Limitation Act excludes the exclusion of last day falling on holiday. For example, your 3 months are ending on Sunday, then it can go on Monday also. Now, this we can keep in mind. Suppose there are very marginal delay of 1 day, etc. We have to keep in, and this section will apply. These are universal, and this will apply. There is no requirement of inclusion or exclusion.
So with this online filing thing, is there any amendment in this? Because the now.
No, still holiday remains holiday. We are not supposed to work on holidays. No, still we can take benefit of this section. I think there is also that one judgment on that. Even if online filing is there, still holiday, you can still get excluded. There is section 14, which says exclusion of time for pursuing wrong forum. Suppose instead of filing before deputy commissioner, you have filed appeal before joint commissioner, and certain time is taken there, and then you come to know that wrongly we have filed here. You can go back to deputy commissioner, and there you can say this time should be excluded. Section 14 permits that. And according to me, that will apply even under the GST also. Of course, if you go to High Court, they have got power, they themselves give the time that you can present your appeal within 4 weeks from this day, etc. So whatever time it may have taken otherwise. But nowadays it is necessary that you should file the writ petition if you want to go to High Court. You should have to file within 90 days or 3 months or that time period. If you are going beyond 3 months, where time for filing appeal has gone out, then they say that is only afterthought and they will not entertain mostly, unless there are any pressing circumstances and they are convinced. Otherwise, if you want to prefer any writ petition against any order instead of filing appeal, the best way is to file it within 3 months' time, at least before 1 week, at least before expiry of the time. And then High Court suppose doesn't entertain your writ petition, you will still get a time of remaining balance of 8 days, etc. Or you can request High Court to give some more time. They will say that you are diligent. They will give 4 weeks also. So this is how we should be cautious about filing the writ petition also, even if you don't want to file appeal. So friends, this is exclusion of time for pursuing wrong forum will also be available to us. Then section 12 says the day on which order is communicated is to be excluded and period starts from next day, etc. These are the provisions of section 12. So these are all marginal cases. You can take benefit of this if it's permissible or available. Then exclusion is only on the holiday. What I mentioned for section 4 is exclusion of the last day falling on holiday. That is another category. And exclusion of the day of service itself is one another available to you. Today. So today will get excluded and tomorrow, from tomorrow. No, either of. Either. So I am not telling about the filing day. I am only saying that the day on which you are served will get excluded. So you can start now counting from 19th onwards. Still, on the day which is the dated order will be on the online. So that date you can exclude. Then if there is a rectification, application is filed within time of 3 months before the authority who pass impugned order, the time limit to start from date of rectification order. Suppose against the adjudication order, you have filed rectification application, then your time limit to file appeals of 3 months will start after rectification order is passed. So you get extended time. These are judgments of the Madras High Court and Telangana High Court that this time should be excluded. Now, in VAT, what we do, even if file rectification, they are also because they are the power to condone. So we are not much bothered. We say we are pursuing until and remedy and they normally condone it. There is no such cases. They are rejected them. But under GST we had a fear, but now they are supported by 2 judgments that it should. So what? Sometime we have got a circumstances. We have no money, or we want to prolong for some time. So best way is to file rectification application within 3 months time without payment. Wait it there. Sometimes it takes 1 year, 2 years also. Sometimes they take more time to decide rectification application. After that, you get the time for filing the appeal if this is rejected. What is filed after 3 months? Now, after 3 months you have filed, then I don't think you will get that benefit because. But that is after appeal, after time of appeal filing is gone, difficult to say that wrong remedy, etc. Pursuing the wrong remedy at the time wasted, time is. No, but you should have filed within 3 months, no? Where they are saying if you are pursuing wrong remedy, then wrong remedy what? Filing appeal with some other. Within time. No, sir, whatever it may be, but it should be within time of filing appeal. If you start doing process afterwards, then they will say it is not maintained because you are not taken your own, you are not alert to your right. Yes. Rectification. No. See, what I am contemplating. Suppose there is an adjudication order. You file rectification application within 3 months. So, for example, end of the 2.5 months. And that rectification application decided after 6 months. So then that rectification order comes. After that, you can file appeal, which will be valid for even original order also. अभी क्या कुछ है तो बताओ नहीं ना सर बराबर है you have got another authority decides in wrong matter reject a rectification application even though the matter is rectified so there could be 2 options available with the assessee to file the appeal against the rejection of the rectification that is always there वो तो टाइम में मिलने वाला ही आपको but if you want to contest even the grounds of original order also that also you can take now after rectification order. So wherever there is a finance problem, 10%, we do some these tricks to take it forward for some time. Time starts there. Time starts there. So I have monarch by kahin ho to kya humne anything Let us be for all knowledge sharing.
Of the that if after 6 months rectification application is rejected, then also you are of the view that from that day only it will be counted 3 months.
3 months. Original order. So I have given 2 orders. Reference judgment case of SPK and Company versus so and so, Madras High Court, and also now recently Telangana High Court. Both have taken the same view. So I think we are safeguarded by that. There is a feeling. Normally what happens, sir? Adjudication order, the main order is a different order. Rectification order is a different order. So if you wanted to challenge that, you should have challenged the original order separately without waiting for rectification. And if you want rectification afterwards, you can challenge that also. But here at least fortunately that the courts have taken view that no, the time limit for filing appeal even for the original order will start from the rejection of the rectification application. So that is how we are saved. Now another thing which I am going to discuss is from when limitation starts. Now section 107 provides as under. Any person aggrieved by any decision or order. Now what is decision we don't know, means whether conveyed in orally, whether in writing, because order we understand. But decision we don't know. Whether somebody was asking whether issuing notice in 74, under section 74 is also appealable or not. But that is a decision taken by them to say that you have committed a fraud and you are covered by the longer period. So whether that is appealable or not. Now on portal there is, I don't think any facility available to file that. But this is an experiment we can do. The otherwise, what is the difference between decision and order? Order comes in communicated manner by writing and something like that, so we understand. But decision is what? It can be on their proceeding sheet to initiate section 74. That also we can say it is order and you should notice according. So we want to challenge that. So any decision or order passed under this act or the State Goods and Service Tax or the Union Territory Goods and Service Tax Act by an adjudicating authority may appeal to such appellate authority as may be prescribed within 3 months from the date on which the said decision or order is communicated to such person. You're running down. Close.
You can
Continue. Huh? પછી લગાવો ને એને બેટરી ચાલુ કરી દો. Now coming to delay condonation, subsection 4, the appellate authority may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be, allowed to be presented within a further period of 1 month. 6 months is for the department appeals. Thus, the limitation of 3 months starts from communication of the order appealed against. So we now will discuss what is communication, when it starts and when it ends. When communication can be said to have been done is matter of fact, according to me. Uploading on common portal is not communication. That is what the judgments have now come, saying that communication should be something which the other person should get knowledge of that. Without that, it cannot be said that it is communicated. एक मिनट जरा जोर से बोला ना. I didn't understand what you are saying. पर वापस एकदम बोलो.
हेलो. फैसिलिटी हम अवेल करते हैं जस्ट लाइक इन इनकम टैक्स. तो वो डिपार्टमेंट ने अगर अपलोड कर दिया है उसके ऊपर और आपका इंटीमेशन दे दिया है तो दैट विल नॉट बी ए कम्युनिकेशन. ए सेपरेट कम्युनिकेशन इज टू बी गिवन बाय द डिपार्टमेंट.
Let us see. आपका कहना है कि मैंने लॉग इन लॉग आउट कर दिया, सपोज मेरा ऑर्डर सर्व हुआ है और कम्युनिकेटर मुझे पोर्टल पे अपलोड हुआ है 10th अगस्त, उसके बाद आपने 12 तारीख को लॉग इन किया था, तो नाउ यू वांट टू से दैट वी हैव कम टू नो ऑफ द ऑर्डर, दैट इज व्हाट यू वांट टू से, नो?
That facility is given by the department to see your intimation.
ठीक है. Now, friends, there is one section 169 which is about service. If the service is done, certainly there is a communication. What section 169 says? आमा केम नहीं रूल मार दिया, एक मिनट अरे रूल हाँ 169 service of notice in certain circumstances. Any decision, order, summons, notice or other communication under this act or the rules made thereunder shall be served by any one of the following methods, namely by giving or tendering it directly or by messenger, including a courier, to the addressee or the taxable person or to his manager, etc., etc. That is our personal communication, as we know. Then second mode is by registered post or speed post or courier with acknowledgement due to the person for whom it is intended or his authorized representative, if any, at his last known place of business or residence. Third is by sending a communication to his email address provided at the time of registration or as amended from time to time, or by making it available on the common portal. By publication in a newspaper circulating in the locality in which the taxable person or person, etc. So now, and last one is if none of the modes of aforesaid is practicable, by affixing it in some conspicuous place at his last known place of business. So all these modes are there. One of them is uploading on the portal by making it available on the common portal. Now, at prima facie, we feel that once the order is uploaded, it is supposed to be communicated also or served out upon you. ना ना बोलो ना सर, हमको तो शेयरिंग करने का है. Yes.
The common dispute revolves around if it is uploaded on the common portal, it amounts to a service. That is what the
Thinking our
when we drafted the law.
Yes.
But they have beautifully pointed out, Punjab High Court said, now see the definition of common portal.
Huh.
That doesn't cover this.
That doesn't cover.
Common portal is only for the front end operations. So common portal does not cover this uploading. And we are saying it's uploading on common portal amounts to a service of the order. There are many judgments even of the High Court saying that served is different than communicated. And the recent Punjab High Court judgment says where it is a common portal. It's not a common portal for the purpose of uploading the order. It is only for the front end operations. So that might stand and the department stands saying that the amount, the moment it is uploaded on the common portal,
Yes.
it's amount of service. No. So beautiful judgment.
Yes, Lordship. तो बराबर है, साहब बोल रहे हैं. So that we are coming to that judgment. So when communication can be said to have been done is matter of fact. That is what we have to see now. Uploading on common portal is not communication unless what the High Court has said we have to see. Now section 146 is under. जो आप अभी आखाड़े साहब ने जो बताया, that is covered by section 146. 146 says what is the common portal. They say the government may, on the recommendations of the council, notify the common goods and services tax electronic portal for facilitating registration, payment of tax, furnishing of returns, computation and settlement of integrated tax, electronic way bill, and for carrying out such other functions and for such purposes as may be prescribed. So this common portal is not meant for communication of the orders. That is what notices or orders. It is only for their own other functions like registration, returns, e-way bill, etc. So taking this base, the High Court has said that simply uploading on the portal will not amount to communication, then time limit will not start running. So this is how some distinction has been made of uploading on portal and communication on portal. We have to take benefit of this only when we are delayed. So as per section 146, portal is not for communication of orders. Communication by any mode when acknowledged by the recipient of order is communication. For email, there will not be any excuse because that is being sent on your registered email and there is no requirement of further requirement because that will be a recognized mode. But still you can argue that also that I could not see email or it has gone on some some wrong email, etc. So that also we can take down. Coming to that uploading on portal. Regarding portal uploading, there is debate whether uploading on portal amounts to communication. The theory is now settled by certain judgments. I have given 4-5 judgments, including a Lakshmi Traders, Punjab and Haryana High Court, and subsequent judgment also. In case of Manoj Kumar, proprietor of Sai Traders, Allahabad High Court said that even if it is uploaded on the portal, it is department duty to show that it has been acknowledged by the party, recipient. Otherwise, still it cannot be said that there is a communication. And Punjab and Haryana High Court also said the same thing. That if, for example, notice is uploaded on the portal, now whether it is communicated to you can be known. If suppose you have replied to that, then it is acknowledged by you, it means it is received by you. Then you cannot take a ground that it is not a valid service, etc. But you have not replied to that, then we can say that it is not communicated to me. And you can still argue that notice is not given and I should be given fair chance. Or order. If after order you are not taking any action, you have not written any letter or any rectification application, etc. or nothing is done by you, and after 6 months you find out that order I want to file appeal, you can still take a chance. There is no communication to me and I will file now when I came to know about this order. But that you have to substantiate. As you just said that, suppose after the date of order you have logged in and logged out, that doesn't mean there is a communication. They have to, it is a department duty to prove that, no, after our uploading, they have written a letter to us or their bank account was attached and still they have not filed appeal, something like that happens, then probably you have no chance to say that there is no communication. But otherwise, एक minute.
They have login on particular date. That data they
No, they have explained on just because of login you have done, so for example, return basis or your liability register. That doesn't mean you have seen the whole portal. There are a number of tabs under that which you have to go through to find out where is the order. That is what Punjab and Haryana Court has said, that it is a complex process and not that easy. And that is why it should be proved by the department by some positive evidence that he has got the knowledge of that, it is always with him, then only that will apply. That also was useful. Consolidated means now we cannot prove even for 24 also whether it was an additional tab or not, because that have removed everything. But this Lakshmi Trader judgment will be mostly useful to all of us, normal, unless there are very unfortunate circumstances.
Also contains who is approved part. To see section 107. What happens is sometimes there are partnership firms where one of the partner is responsible for saying compliances, and then there is attachment of another part. So when we say who is the aggrieved party,
The assessment will always be on the form, no?
yeah, it will be on the firm. But then can the other partner say that, I was not aware of it? The responsibility was with the other person. And then now I am the aggrieved party. So there is no delay at all.
In filing
Whenever I
appeal.
came to know, I have taken
No,
sufficient
but
action to.
out of all partners, somebody has acknowledgement that, or they have, somebody has come to know that order is there by any mode.
In fact, there was no.
No. What I want to say is, even if one of the partners has seen it or acknowledged it, and department has got a proof of that, then I don't think another partner can take a plea. Otherwise, there is no end to that. No.
In one of my cases, there has been no. There has been no replies.
Then the thing, na.
We can.
Then you take that, but you don't say that I was this partner was looking and I was not aware. That will not work. You have to prove that whole firm was not knowing it.
Yeah, only the.
If it is on the personal penalty, then you can take that plea that.
I was not
It is
aware.
on.
I have not seen. That is also possible. ना कोई फिजिकल क्या आता है अभी. अच्छा. हाँ, that is what. वो that is possible. In central department में करते हैं, अपना स्टेट में तो ज्यादा करके सब ऑनलाइन ही हो रहा है. हाँ. ठीक है, अगर ऐसा कुछ हुआ, फिजिकल हो गया है और तो फिर आपको कोई चांस नहीं है. Then you have to take from that date itself.
This happens in central, that they just send the orders through post, but it's not uploaded even after 3 months.
No. You mean to say physical order is given?
Physical order is given.
But
but it's not uploaded on the portals for more than 3 months.
According to me, the view is that time limit for filing appeal is standard. It cannot be extended because of uploading is later on. You are no doubt. First appeal, you are also liable. Means you can file physically. So the court says that you should have filed physically within 3 months' time. For tribunal, as we know now, no physical filing is possible. But still on the safer side, you should file it by registered post. Send it to their address. Let it be then uploaded and then you upload the appeal. So your work will be easy. Otherwise, simply because there was no availability of the order on portal, I could not file appeal. That will not work according to me.
The only thing is you will have to put online, but you are able to file online.
Online.
So that.
तो ये फिजिकल भी लेते हैं.
but अगर
बट ट्राइब्यूनल का इश्यू आएगा. अभी अपील ऑर्डर सपोज अपलोड नहीं किया विद इन 3 months, देन हाउ कैन यू फाइल इट?
CRN not available, ARN not available करके आपको मैनुअली सब भरना है.
ठीक है.
दोनों में कर सकते हैं.
अच्छा, इवन इफ इट ऑनलाइन लॉ, अच्छा देन कोई प्रॉब्लम नहीं है.
So we have to do it even if it's physical within 3 months.
Yes.
So date of communication would be physical. हाँ. नहीं तो बट वो पोर्टल पे नहीं आ रहा ना, मतलब मेरा वो. हाँ. Okay.
स्टार्टिंग में हुआ था, अभी तो आई थिंक दे आर गिवन. अरे कुछ नहीं होता है तो आरपीडी से भेज देने का, एक बार एक्नॉलेजमेंट लेके रखो. हाँ दे पुट. बट कभी कभी वो भी नहीं होएगा, लेट हो सकता है. बट यो whatever request you are making for uploading, you should put in writing. So you will remain a proof with you that I was trying. चलो अभी जल्दी करता हूँ.
Sending can be somebody sent, but whether it is delivered, whether it is read out or not, it is different.
But when mail has sent, but someone has to receive, delivered. You know, let's say I have a full message. It has been not delivered. The server, it has struck. So I think when the delivered happened, now whether he read it or not it. So that would be the mode of the communication which I have to come.
No, you mean to say by sending email still it is not service.
The moment it is delivered, because when you send message, you will come, it is delivered, undelivered, or suspended, or so. When it is delivered, so the moment it is served the notice, sending for is a approval, it is a.
So you mean to say you have to see department's record? Whether it has to them, whether it is delivered or not, in their portal it has come or not.
Undelivered or it is bounced. So that way we can.
But that information you take from the department. No, sending means the language says on the registered email of the party. So once it is dispatched to that or uploaded on that email, according to me, that should be service. Now, if you say that you have still not received it, it's a matter of fact which you have to find out. But in that case, you have to first obtain the information from the Department of Filing RTI, whether this has been come as a delivered to me or not. And then you can take a further step that is not delivered. Otherwise, if you jump and they say, though, it was delivered also, then you are no case. Yes. But these are the cases where suppose accountant was looking in and you could not manage, etc. These are a matter which High Court can decide. Here, I don't think any chance of getting it condoned on that basis. So here always you have to stick to that. I was not knowing uploading. I came to know only my bank account was attached. From that now take 90 days. Now presentation before authority. When there is a delay, you have to put up an application. And in that you have to give a ground why it was delayed. So in case of delayed appeal, the ground of condonation should be given with proper reason. Because now at least in under BST Act or VAT Act, the sympathetic view was always taken. Normally, very rare cases they used to reject it and 99% they used to accept it, whatever it may be, with some cost and etc. etc. But in CGST, I have seen they are very punctual or whatever you say, their view are not that liberal. And they mostly tend to reject it. And there are where they have not even given opportunity and rejected it. In my own case, it has happened. After hearing me everything, they have written what is my submission, etc. And then those 2 lines found that this there is a delay after 90 days, but within 30 days, but no application is filed or no submission is given, rejected. Now coming to that, what should we do? If delay within 30 days, there are more chances of delay getting condoned. Reasons can be medical, finance shortage, traveling, consultants difficulties, social or any other fact as may be existing. So that you have to find out which is provable. Sometimes what happens, you say that I was traveling and you have no tickets, etc. available with you. Then again it becomes a false statement. So find out what reason can be given which is best supported by documents. Medical, you can obtain some certificate from the doctor and say that I was not fit medically. Finance shortage, from bank statement, they will find out whether you had pay money or not. But you remember, we can file appeal even without paying 10%. So better you file it if at all really financial is the problem. And then you can fulfill the deficiency even further time of some time they will definitely available to you. Because even before rejecting it for non-payment, they have to give you hearing. And in that time, if you are paying, probably you have chance of getting it filed in time. So these are some of the things we have to think of. If uploading on portal and no knowledge, the same can be mentioned as ground for condonation. In case of delay beyond 30 days, normally it is due to no knowledge of uploading on portal. The above judgments can be used for said purpose. But go through facts minutely before making any statement, because if proves to be something wrong you have mentioned, then everything got against you. Matter before principal bench, the learned Rana Sahab was referring to that. Now, this matter was before principal bench. I don't know how principal bench got a jurisdiction to consolidate all the appeals. This is very funny. And how they are going to hear all 500 and 600 cases and what judgment they will pass. According to me, it is the benches, the respective bench which will decide whether there is a communication proper or not, whether 90 days taken place or not. All the things within the jurisdiction of the particular bench. And they say that on the website we get it that it was lastly on 20 July 2026. But as Rana Sahab said, it has been heard and still it is not out. What is the order? So let us see what happens in the principal bench. I think they may be talking about delay beyond 30 days or 90 days, beyond 3 months. Where there is no other ground like communication of the order, all these points are not there. Purely delay. Then probably this may be issue before the... But here we can always go through, first of all, what is the date of communication. Accordingly, we should try to get delay or no delay. Now, hearing before rejection on ground of delay. The appeal may be delayed. There are cases where the first appeals are rejected due to delay. In such cases, the appellate authority is required to give hearing. Reference can be made to Honorable Gujarat High Court judgment case of Watch Row Systems, wherein it is held that opportunity of hearing is required to be given before rejecting appeal on ground of delay. So even if suppose in the your grounds of appeal, etc., or a separate application for delay is not filed, you can still in the hearing they are bound to give you, and in that hearing you can explain or give reasoning, and that can be considered. But and if still it is not considered and no hearing is given and dismissed, then probably you have to run to the High Court. Or now we can file to tribunal and say that this opportunity is not given, so let it be remanded back. So something like that we can do it. But that may involve 10% more payment also. Then delay in filing appeal before Honorable Magistrate before 30/7/2026. It should be after, no? Umang? So appeal before Honorable before 31st. Delay in filing appeal before the Honorable Magistrate before 31/7/2026 means I was supposed to file up to 31st July 2026. File after that. So taken in that perspective. The appeal before Magistrate are filed as per section 112. Because of non-information of Magistrate, the appeals could not be filed as per time limits. Therefore, the circular was issued about modalities for staying recovery. Circular number 224. Everybody knows that you have to file, you have to pay 10% and file that circular के साथ एक form दिया था. Exhibit A, na? That you have to submit. Then they would used to stop the recovery. But that was only for recovery's purpose. Now, government issued notification number so and so dated 17/9/2025 prescribing 30th June 2026 as date for filing appeals before GSTAT for orders passed prior to 31st March 2026. So one time limit was given that for all the orders passed prior to 31st March 2026, the date for filing second appeal before GSTAT will be 30th June 2026. So friends, we tried to file it, but we could not complete it. So there is now further extension. The said date was further extended to 31st July 2026 as per notification number so and so dated 30th June 2026, including for orders passed up to 30th April 2026. So when extension came, they covered the orders passed till 30th April 2026. The issue is whether the condonable period of 3 months as per section 112(6) is available after 31st July 2026, where order is passed before 30th for 2026. For example, अभी September 2025 में order pass हो गया था. As per this extended time, you should have filed up to 31st July 2026. But you could not file, and now you are filing August, September. Whether that can be condoned, taking tribunal has power to condone in 3 months' time. Or whether the condonable period of 3 months is also covered under that 31st July. What will be your views?
I think President Tribunal in one Delhi seminar has expressly said, don't worry, there are
that is the tribunal members have said. Mishra ji said. If that is the documented one, that is well and good.
Of course, there is reason.
Of course, proper reason, the same thing we did not come to know, or our consultant failed to do. No, that taken, but there are certain people still not having token or nothing and still appeal remaining file. मेरे पास 4-5 केस है अभी.
GSTPAM portal, I like Michael because everyone is complaining online. So now there is a new issue also which has cropped up. The GSTAT portal is calculating 90 days from date of order, but the provision reads 3 months.
3 months.
So that is why even for orders which are say issued in May or June of 2026, which are now becoming due for filing, they are asking compulsory for either a token number or filing of condonation or delay. In spite of the fact that 90 days, 3 months is not over, it may be 91st day because calculation wise, but it is still asking. So what is happening is now, do you have a token? You have to say no. Will you be filing condonation or delay? There is only one option, yes. So you have to file yes, go to documents tab and file a letter saying that this is filed in time. So this may be subject to scrutiny by the registrar at the time of admission.
In my
one
I think
case,
Umang, that may because of constraint of the portal, how they can prescribe 3 months?
no,
They have to put in days only.
It's a technical issue. So in the back end, the portal is hard coded to 90 days
90 days.
when it should be actually plus 3 months. तो उसके वजह से it can be 89 or 91 days, whatever.
Yes,
उसके वजह से issue आ गया है. ये नया issue है.
no, no, in my one case, same thing happened. So I am speaking.
Acha, acha.
So in my one case, same thing happened. There was only a difference of only 1 day.
1 day.
So this two options cropped up there. कि either you give token number or file a condonation application. So there I give explanation because as per law there is no delay. However, because of the portal issue, I am giving this explanation and I filed that application under the tab condonation of delay.
But how that? What was the date of your order and or 3
There,
months?
that was within time. The 11th of this month was the last date as per the law, and I was filing the appeal on 11th only. And on 11th, this was.
So you received on 11th May.
No, this month.
This was the last day. So you
11th
received the order or date of order
Yes,
11th
yes,
May.
yes, yes.
So May 11th to 11th June, 11th July, 11th August.
No, it was
एक
12th
गड़बड़
May.
है, वो 10 तारीख
Order date was 12th May.
12th May.
And when I was filing on 11th of August, this was cropped up.
Okay.
Because you have to file condonation of delay or token number. So in that case, I have filed the explanation, and in the tab of condonation of delay, I uploaded that.
but then आपने 5,000 रुपए भरा क्या?
हाँ?
5,000 भरा है?
5,000 तो भर दिया ना?
नहीं, एक second. So what sir is asking is, for condonation delay, there is an additional 5,000.
No,
rupees as
I have not paid
interlocutory-
that. I have not paid that.
Interlocutory application.
No,
का
no,
5,000.
I have not paid that.
That system is not
Because
asking.
as per law, there is no delay.
पर एप्लीकेशन तो किया ना आपने?
Application किया because of your portal issue.
नहीं, sir. In the while filing the original appeal only, this issue is cropping up, not after. This is not post facto. When he is filing the appeal, the actual appeal, not an application, the actual appeal, this issue is coming because portal is calculating incorrectly.
Yes.
So you are forced to upload something in condonation delay. That is an explanation.
But if that is going to be your application or condition of delay, you have to pay 5,000. No?
No, but
No,
this is,
no.
When this is not an application.
When as per law there is no delay, why should I pay?
हाँ.
But that will decided after considering your application. तो application तो पहले maintain करवाना
No.
पड़ेगा.
When portal is showing wrong thing, it should not be punished to the taxpayer. At that time, we will
So
fight.
there is no delay. There is no delay.
I agree, Umang.
हाँ.
But I have not done any delay or there is no delay. When you will be able to say it?
So
When
at
your
the-
application is taken for hearing.
so when
So that
registrar.
application has to be maintained, no. They
Ah,
say
so-
that you are not pay 5,000, will not consider your application.
No, so no.
That should not happen.
एक second.
I agree, I agree.
They have paid the court fees which are required at the time of filing.
वो तो
Whatever the
बराबर है.
court fees, 25,000 say he has paid. Now, for what you are referring to is that interlocutory application का 5,000 रुपया. Correct? But that is only when you are making a separate application. Correct? Secondly,
ये कंडोनेशन में डाला ना उन्होंने.
नहीं वो टैब कंडोनेशन डिले के टैब में डॉक्यूमेंटेशन में ये लेटर डाला हूँ.
लेटर डाला मैंने.
कि मेरा is in with time, but because of portal limitation, it is asking me to upload something in that portal.
Otherwise, I am not able to file.
So when registrar will take this up, he will have access to that. When he opens the letter, he will go through the letter.
Yes.
If he has objection, he will put it before the bench
Yes.
and for admission, or else directly give for admission. That is what I understand.
Because legally there is no delay.
No, that's right.
Legality is more important than technical things.
तो आपका 5,000 बचेगा
is the
तो
law.
पार्टी देना पड़ेगा सर.
So what?
Sir, 21 days in certain.
No, not at all.
મેના 31st ડે આવે, જુલાઈનો 31st એટલે એ લોકોનું જલ્દી પતી ગયું.
Sir,
90
sir, उसमें they have not yet connected the portal with the COD application separately. That is why probably till now it is not asking for the separate payment of the filing fees, which is the 5,000 rupees. So till now it is okay. But if in future, if legally you are supposed to make a payment and you have not made, then also you are able to file it with this application. Then you may get a defect memo through the registrar, and with the
At that time
you can comply with that court fees payment.
वो तो बराबर है. That I think that should be the real purpose. So anyhow, we will now go further. For example, in normal, what I was discussing is whether 3 months are still available or not, according to, as Akadi Sahab said, and according to me also, and as per the Mishra Sahab of calendar month. कैलेंडर मंथ जो डेट को मिला उससे 3 महीना गिनो. For example, in normal course, for order passed in April 2026, if the appeal could not be filed up till 30th July 2026, the taxpayer gets further 3 months condonable period. Same situation should apply now also. So those who could not file appeals up to 31st July 2026 can file delayed appeals with condonation application in form GSTAT form 01. It will require fees payment of 5,000. Subject to now, as you say, there is no delay and we can simply file a letter.
Then you need to file application, pay
5,000. जहाँ डिले नहीं पर टेक्निकल डिले आ रहा है, there you can file a simple letter explaining the case. पर उसको नंबर सेपरेट नहीं आएगा. It will go along with the appeal only. ठीक है. आएगा, I think so, maybe. Because that will be first disposed of, then your appeal will be admitted, no?
Asked to either file COD if you have not filed. If you file COD, you will be asked to pay that 5,000 rupees if you have not paid. भारत कोर्स से सेपरेटली आपको 5,000 भर के डालना, क्योंकि वो लिंकिंग अभी है.
लिंकिंग नहीं है. ठीक है. So now our minds are clear how to proceed. Pre-deposit for penalty appeals. Friends, as per section 1076, the taxpayer is required to pay 10% of tax dues for getting the appeal entertained. From 1/10/2025, the amendment is made in section 1076, where it is provided that in case of order not involving tax dues, that is for order levying penalty, interest के लिए अभी भी नहीं है, but order of levying penalty only, 10% of such penalty amount is payable as per pre-deposit. The debate was going on about its effective applicability. एक तो पेनल्टी का अमाउंट है तो यू हैव टू पे कंपल्सरी बाय कैश, तो थोड़ा वो अरेंजमेंट ज़्यादा करना पड़ेगा. एंड क्वेश्चन इज फ्रॉम वेयर दिस अप्लाइज. अभी एक सिचुएशन ऐसा लोग बोल रहे थे, यू आर फाइलिंग अपील आफ्टर 1/10/2025, यू हैव टू पे 10%. देन द व्यू चेंज. लाइक फॉर एग्जाम्पल, दिल्ली हाई कोर्ट हैज कम आउट in case of Gaurav Jain, and which it is held that when the proceedings were initiated prior to 1/10/2025, the position will be governed by the old provision. So, suppose your penalty proceedings are initiated prior to 1/10/2025, though order is passed after 1/10/2025 or order is served after 1/10/2025, still you will be governed by the old provision, and that will go up to the tribunal stage फर्स्ट अपील के बाद भी वो चलेगा and without making 10 pre-deposit you can file the appeals against penalty orders.
So, sir, I have a query here, which means according to this, if first appeal, let's say first appeal was filed prior to 11025, tab there was no pre-deposit, nahi bhara. Abhi, when I am coming to tribunal, that time also I can take advantage of this,
Yes.
even though because the order of appeal is say passed in March 2026 or April 2026. Now, when I am filing tribunal appeal, I don't have to pay additional 10.
Nothing.
वो जूना 10%
Because
सवाल ही नहीं है.
initiated, proceedings are initiated prior to 110/2025.
Okay.
अपना जो जजमेंट अंकुश ना नागपुर बेंच वेट के राय में जो आया था ना अंशुल एक्सप्रेस
अंशुल
सेम
अंशुल
लॉजिक दे
Express.
अप्लाइड. मेरा एक और कहना है कि अपन जो अगर इफ यू कंपेयर द लैंग्वेज बिटवीन दैट अमेंडमेंट विच केम एंड नाउ व्हाट दे आर प्रोवाइडेड, स्टिल वी कैन टेक सम still more different view. It appears from the precedent that when proceedings have commenced after 110/2025, though period is prior to 110/2025, 10% pre-deposit condition will apply. For example, let us take a period of 21-22, whose proceedings are initiated for levy of penalty after 110/2025. Then according to this judgment, you will be required to now pay 10% pre-deposit. But can we still argue further that no, in relation to all the periods prior to 110/2025, the pre-deposit should not apply? Because this is not, if you compare the language of VAT under section 26 and here, there is a vast difference. There it was same while filing appeal, pass for the orders passed after so and so date. So here that language is not there. Here state what they have provided under 1076 is, provided that in case of any order demanding penalty without involving demand of any tax, no appeal shall be filed against such order unless a sum equal to 10% of the said penalty has been paid by the appellant. Now, this is something putting a new condition, and there is no retrospective nature given to it. So, it should apply prospectively. And one view can be that it should be only applicable for the periods after 110/2025. It is worth टेस्टिंग इट. आपकी तो शायद उनके पास जो केस गया दिल्ली हाईकोर्ट वगैरह में वो बेस्ड ऑन द अर्लियर प्रोसीडिंग ओपनिंग. नाउ वी कैन स्टिल स्टार्ट आर्ग्यूइंग ऑन दिस व्हेन यू हैव नो मनी. हाँ, वो कासिम दादा. It is a very new condition they have put up, and that is how we can still argue that it should not apply to any prior period. But of course, subject this is how we can justify before the court. My personal view is that as per language of provision, the same should apply for period commencing from 110/2025 and for earlier period, so no such condition should apply, even if proceedings are initiated after 110/2025. The issue is required to be contested separately. Then practical experience of hearing before GSTAT, Rana साहब ने मेरा काम बहुत easy कर दिया. Yes, yes sir, बोलो ना. Yeah.
The dispute before the court, you mentioned one particular judgment of Delhi High Court. The issue before that was that Kasim Dada, what when the lien is created before 110/25. After
Kasim Dada.
My query is something different, because in my case, what happened is, before the proceeding is initiated, the tax was paid. What the CGST authorities would do, they will initiate 73 or 74 and they appropriate the tax. So what the order finally ends up in the demand of penalty only. So the proceeding is traveled through 73 and 74. So if you see the wording, the order demanding penalty. So what it means, order demanding penalty? Because the objective behind 10% part payment to be brought into the act was taking into consideration the section 129 penalty. Because after February 19, we made it not tax only, but the penalty of 200% and some 122 penalties. So the object behind the amendment to be brought into that act is to separate penalty orders. So the wording is not supporting that. Order demanding penalties. So if my order has initiated from 74, through DRC 01 and end up into demanding penalty only because the tax has been appropriated has been paid before
So
the
you
initiation.
mean to say, sir, ki suppose 100 rupees tax,
Oh.
which you already paid prior to initiation of proceedings, so 100 zero ho gaya.
Still they
But they
initiated
levied
73.
interest and penalty of say 200 rupees. Now demand will only come for interest and penalty.
Penalty only.
And that is whether that require deposit or not.
That could be an issue. In my opinion, it should not be. Because when I have uploaded one such appeal before GSTAT, they ask whether you accept the calculation by the portal and you say yes. So then they ask for the part payment calculated by the portal. There it was not calculated. But in CGST, in first appeal, the commissioners are asking for 10% penalty, part payment for such an eventualities.
Sir, generally in all such cases, what you are referring to, that is correct. But in all such cases, if you have paid prior to show cause notice, then in the show cause notice, they will be issue a show cause notice. In that show cause notice, they are also asking for payment of that. They are not saying, and when you will get an order, they are saying that, okay, you have paid this, we are appropriating this thing. So in the appeal, while going for the appeal, you can challenge that we are also challenging tax and interest as well. So by considering that, you will not be required to make any separate payment while filing an appeal. And in the online portal, you can make that 10% pre-deposit to 0. Along with that, you can write a letter as well.
Two things, let me clear. My issue is not whether the tax has been paid prior to issuance of the notice or after the issuance of the notice or during the proceedings. That is not an issue. In the portal, they did not ask for that 10% of that penalty, which finally culminated into a penalty order.
Penalty demand.
Can it be said as a penalty order when you travel through 73, 74? Okay. It's an issue. Okay. Even the portal did not ask me to file 10% of that penalty. Because the order was culminated as finally a penalty order. But the portal did not ask me 10%. So here the issue is the order demanding penalty means what? Even in 7 through 73, 74, it could be said as a penalty order or it should be a separate penalty order only.
मेरे लगता है आपका व्यू बराबर है सर. You are perfect. Because here they say the provided that in case of any order demanding penalty without involving demand of any tax. But when they initiated, they were demanding tax also. But you have paid, it has become 0. But still it is demanding tax. And as rightly said by Monarch, that if you have paid under protest, then even there is no question because that under protest amount itself is considered for 10% pre-deposit. There are judgments of the High Court that if you have paid under protest, then that is still not appropriated and that can be still considered for your pre-deposit. There is no need to pay further.
So ideally, the system design is such that appropriation should happen after the order is part, not before. So in the order, if the appropriation is done, the problem is at the time of filing appeal. So like Monarch Bhai was saying, even if you are challenging the tax dues and interest dues, when filing the APL 01 उसमें वो टैक्स आएगा ही नहीं, तो आप वो चैलेंजिंग में एज पर डिमांड 0 एज चैलेंज 1 लाख रुपीज फॉर एग्जांपल, तो 1 लाख लेगा ही नहीं. सिस्टम फॉर्म लेता नहीं है. लेता है अभी?
उसको आप चेंज कर सकते हो. वो जो डिमांड में है ना, वो जो 0 आ रहा है ना, उसको आप चेंज करके जो आपका ओरिजिनल डिमांड है, यू कैन यस मैन्युअली यू कैन चेंज दैट टू 1 लाख रुपीज डिमांड. और जो भी आपका इंटरेस्ट डिमांड है, भले उसमें ऑर्डर में अप्रोप्रिएट किया है, दैट यू कैन चेंज इट मैन्युअली. और जब भी आप प्री डिपॉजिट का जो 10% है उसको आप 0 कर दो. बट उसका हाँ सेपरेटली लेटर फाइल करना है.
मतलब वो ऑनलाइन ऑर्डर का रेफरेंस नहीं रहेगा, आप मैन्युअल करके उसमें ऑर्डर डिटेल्स डालते हो. बेसिकली ऐसा हुआ. करेक्ट.
Normally, it is to apply to the separate penalty orders. Only levying penalty, no sale, no purchase, etc. जो होता है ना बोगस का, उसके बारे में.
जिसने ये किया है बोगस वाले, तो बोगस वाले को कुछ भी था ही नहीं. विदाउट प्री डिपॉजिट दे वर गोइंग फॉर द अपील.
अभी वो कुछ भी नहीं करेंगे। करो जो रिकवरी कर दो। अच्छा, अभी जो हियरिंग चालू होएगा, now what we attended 2-3 matters before Mumbai bench. There are 2 courts, court 1, court 2. कोर्ट 2 का हियरिंग चालू नहीं हुआ है, जो आज आए थे वो कोर्ट 2 के मेंबर्स थे। कोर्ट 1 का हियरिंग चालू है फॉर एडमिशन नॉर्मली, एंड दे आस्क भाई चलो आपका डॉक्यूमेंट्स तो बराबर लगाया है, सो इट इज एडमिटेड। दे पास प्रोसीडिंग शीट ऑल्सो ऑन द पोर्टल इज मेक्स अवेलेबल। अभी लास्ट हियरिंग में उन्होंने क्या बोला कि उनका अपील एडमिट किया है, अभी नाउ यू फाइल द रिस्पॉन्स, डिपार्टमेंट को, रिस्पोंडेंट को बोल दिया by next date you should be file your response. Problem will be like number of dealers, including in my office also. We have filed appeals with basic 4 documents: SCN, OIA, OIO, OI, and the grounds of appeals. Now suppose he files response based on that only, without we have not uploaded the documents, supporting documents, purchase invoices, support the bogus का कोई claim है, या any other claim for which documents are required, we have not filed it. So tomorrow they may file response based on the grounds only. They say no documents are available, so we cannot submit anything further. Now whether we'll get opportunity to upload at that time or not, वो एक issue आएगा. So better thing is that now, before they are taking up for final hearing and they give their response, you should submit your or upload your documents. So then there will comprehensive response from them. Otherwise, what view they will take, that is a matter we have to see now.
They said that they will going to give us the opportunity for uploading the documents later on, that there is some missing documents or something like that. You can have the opportunity to upload the same.
After getting their response.
Yes. So just now we have spoken with this.
वो डबल प्रोसीडिंग हो जाएगा, ठीक है।
Are they not going to differentiate one is an admission hearing?
That is what
one is an.
We are getting confused. In my first hearing, when I went, they said, okay, your appeal appears to be proper. So we now adjourn it for 4 weeks. अभी 4 weeks के अंदर क्या करना है मालूम नहीं था अपने को, तो नेक्स्ट डेट अभी आई थिंक 25th को है ना रे। दूसरे मैटर में गए, बोले योर अपील इज इन परफेक्ट है, वी विल थिंक ओवर इट, आपका रिस्पॉन्स फाइल कर दो। डिपार्टमेंट में ऐसा बोल दिया उन्होंने। अभी सपोज वो टाइम पे अपन अपना डॉक्यूमेंट फाइल नहीं किए हैं, then what response they will file based on that there are no documents, so this appeal cannot be considered and to be thrown away, etc., etc. They will certainly argue on that line. ऐसा आपको हाँ उसमें एडिशनल में डाल सकते हैं सब डॉक्यूमेंट।
In that Churchgate session, somebody from tribunal said कि if there is a defect memo, then you will be informed by the registrar office, and within 7 days you have to cure that defect. If not, then it would be put up before the member tribunal. I thought that kind of hearing it was.
No. That is also that should be there. But अभी जो है कुछ mix up हो रहा है. I think better we can go to them and get it clarified. Jatin bhai, you have to go to them and ask for what is exactly the process.
So what I have understood is they are copying sestet. So they are copying sestet, and registrar, even if there is no defect, is right now, especially in Mumbai bench, they are advised anything and everything has to be placed before bench, even if it's for 5 minutes. So right now what is happening, like you said, Aya, your matter seems to be in order. Then department representative will say we don't have access. So judge will say please get access, and that is how admission is happening for now. So 10 minutes, 15 minutes, mein all 6 matters are heard. That is what is happening.
That should be the real understanding. But now lastly they have said okay, you file your response. Now that will create a problem.
So response, we will also have 30 days to respond to them. That will come up in our portal. In GSTAT portal it will
go up. अपन कुछ document supporting submit नहीं किया. It is our.
हाँ तो वो आप अभी additional document tabs है, उसमें आप कर सकते हैं.
But इसके पहले समझो 30 days के पहले उन्होंने reply file कर दिया. Then it will be again mismatch and how to do it.
वो थोड़ा रहेगा, but as see, President GST80 only said you file only basic document. So we are following that. So there has to be some.
Some. But if you have got a meeting to arrange with courtroom number 1, basically, you get it clarified.
Yes,
Sir,
yes.
we should have standard process.
ये 90
So we
days
should
वाला
not
भी
have anything.
रिप्रेजेंटेशन कर ही रहे हैं, तो उसके साथ कर
ये
देंगे.
करो. ये उनको माइक दो ना.
See, when we submitted a document at that time, see, normally it is a audit or scrutiny based demand or. We have already submitted a document. The document which we have.
Documents means we have submitted HCN. OI.
No. I'm not talking about tribunal. I'm talking about the departmental response where we have submitted a document. They have
You
gone-
mean to say submitted in the adjudication level?
Adjudication level. So they have to give the response based on the document what we have submitted to them at the initial level, at the first appeal level, at adjudication level. Now we may not be required to again submit it to the tribunal. I already submitted there.
That is one thing.
So I additional like this 2A 3B differences. Now today the Surat bench has given the judgment, it is not applicable 2A 3B. That's a different story. Now what 2A 3B mismatch is, we said that you give us the invoices which are not reported in the 2A, of which you have created the demand. So in such cases, you are required to produce a certificate as per the circular. If that certificate is not produced, then you can produce it live. So it depends upon facts to facts.
No, I am basically talking about where suppose our purchases are held to be non-genuine, etc. So we are supposed to put our records like purchase invoice, delivery challan, LR.
That you must have produced at the time of the first appellate or adjudication level.
No, sir.
But is it available to the tribunal?
But that is what we are talking about the department response, not the tribunal.
Sir, but whenever you another order, say for example, adjudication order has been passed, thereafter first appellate order has been passed. So all the previous order gets subsidized into the new order. So accordingly, you have to submit all the documents afresh before that authority for the verification as a evidential evidence for your appeal. It is not something that they have to get it from the adjudication or they have to get it from the investigation. That is what
It's
is
like-
my understanding.
It's like
You have
each
to
appeal
submit.
is a different appeal, and I think we have to submit all the documents again.
Again.
So we have to
And
submit
like-
our evidence.
There are two possibilities. One is that as Janak says, शायद अपने adjudication में दिया होगा.
But they do not take
First
it
में दिया होगा,
forward.
so
They
we
do
can
not
stay
take
like that. But जहाँ कुछ दिया ही नहीं है, we could not submit it for any reason. There should be more cautious. अभी के immediately कर देना चाहिए.
they have for that, if they send you that response also, they have hardly 1 or 2 uploading in that response windows. When you submit the initial documents, there are more tabs to upload documents. But when you have the response window, there are only 1 or 2 tabs. And so you'll have to merge all the PDFs and then you'll have to apply that file. Yeah. So, and specifically into that specific MB, what they required. That's why.
સુરત બેન્ચ નું
Yeah.
શું થયું ભાઈ? સુરત બેન્ચ what did? थोड़ा नहीं बोल के रखो, मालूम पड़ेगा.
No, I have not received the text of the judgment, only gist is there.
Okay.
वो रोज CB खुद ना
And nowadays they are sending this SMS etc. आप ध्यान रखित रहो, मालूम नहीं पड़ता है कभी हेयरिंग आ जाएगा, क्या होता है. So कॉज लिस्ट वगैरह देखते रहो. वीडियो हेयरिंग
Example could be considered as an additional evidence. Additional evidences and additional submission would be rated differently. The additional evidences, it has to be with the permission of the department.
No, I am thinking from the point of view, as Janak says, in adjudication you have submitted the documents. Whether tribunal will have access to it, and if by that time hearing it will available to them or not. If I want to demonstrate that, see sir, I have got purchase invoice, but it is not available in my hand, they say I also not having it, then we will in a bad situation. That is why uploading of those, what we now again rely, it will be better.
So you rightly pointed out We have uploaded we have uploaded OIO, we have uploaded OIA. But if we have not uploaded the response to the show cause notice, probably the answers could be in that answer.
Nobody
reply
has
to
done
show
that.
cause notice.
Nobody has done that,
They-
according to me. Of course,
absolutely.
few people might have done it.
It was allowed. You only
It was
applied
allowed.
these
You can
four,
file up to whatever.
uploaded these four and go on. So probably that answer is in that, and then the department's onus is to comment on that, because that is what the second appeal is. They did not comment on the submissions made.
Chalo. ठीक है. So I conclude my hearing before you. Thank you very much.
You have any online questions, Praveen? Hey? We'll just check if we have any online questions. No questions. So I would request our convener Monarch Bhatt to give a worthy vote of thanks.
So we all agree that we had a wonderful session by CB Thakar sir on the recent topic of condonation of delay, penalty proceedings, and what are the challenges we are facing currently for arguing before the GSTAT. So we are thankful to you, sir, for your detailed and what are the experiences you have gained over the years to share with us on this particular topic. So we are thankful to you for sharing your valuable knowledge and insights with us. Further, I also thank all the participants who have joined us physically as well as online, and all the team, those who have supported for organizing this study circle meeting, and our president. Is there any announcement? And now I request our secretary Ajay Bhai to have some announcement. Thank you. Thank you so much.
Thank you, Monarch. As usual, we have our flagship event, namely the Intensive Study Circle, which is starting on 3rd of September. We'll have a series of sessions in that, and accordingly, you will be receiving the flyers. But the inauguration of the, or rather the first Intensive Study Circle meeting is going to be held on the 3rd of September, and it will be in a hybrid mode. So this is a flagship event. I want maximum enrollment for this. I request all the members who are present here, as well as those who are present online, to please enroll for this course, because this is a very, very important event of our association. It gives you knowledge at a very, very reasonable cost, where you can interact with the best of the, you can pick their brains. So this is I would request everyone to enroll in this. Thank you. Okay, and 21st, there is a mega guidance cell online, so at 6 p.m. So all the members are requested to be present online for this mega guidance cell also. Thank you.
तुझी मुळी कडकडणाऱ्या नभा अस्मानाच्या सुलतानीला सबाब देतीची भा सह्याद्रीचा सिंह गर्जत शिव शंभूराजा
दरी दरी नाद गुंजला महाराष्ट्र माझा
काळ्या छातीवरी कोरली अभिमानाची लेणी
मोलादी मनगटे खेळती खेळ जीव घेणी
दारिद्र्याच्या उन्हात शिजला विठ्ठलाच्या घामाने भिजला देश गौरवासाठी झिजला दिल्ली देवी. जय
National anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलचित गंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता
जय हे
जय हे जय 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 जय